Hello, how are you all? Welcome to my channel Law Made Simple with me Vidya Reddy. Today, in the series of labor law, let us learn about retrenchment. Earlier, we have studied about layoff. I have already said that layoff and retrenchment were earlier not included in Industrial Disputes Act 1947. But when there was a great famine in West Bengal in early 1950s, when the employers failed to recruit the workers for employment, then these terms layoff and retrenchment were included. The retrenchment is defined in section 200 of the Industrial Disputes Act 1947. Let us look into the definition. According to the definition, retrenchment means the termination by the employer of the services of a workman, and such termination may be for any reason whatsoever. The termination should not be as a measure of punishment by way of disciplinary action. So here the Industrial Dispute Act defines retrenchment as it is the termination of the workman by the employer, and the termination may be for any reason. The termination should not be like a punishment. And what are not included under retrenchment is voluntary retirement, termination on grounds of continuous ill health, or non-renewal of contract of employment. All these are not included under retrenchment. Let us look into the judicial approach. The object of any definition is to give clear notion and meaning of the term. When the definition is ambiguous, it leads to controversy, and the courts may express different opinions. In relation to the term retrenchment, this has happened, and the courts have expressed different opinions. So, as we have studied in the interpretation of statutes, the statute or the definition should give a clear-cut meaning, and it should not be any ambiguity and controversy. So, we have certain cases in State Bank of Patiala versus Santosh Gupta and in State Bank of India versus N. Sundaramani, the court held that we have defined according to the section 2 of the ID Act that retrenchment is any termination for any reason whatsoever. So the court held that for any reason whatsoever has a wide and varied scope, and retrenchment doesn't mean discharge of surplus of labor alone. So when for any reason whatsoever means it can include any kind of reasons. It does not only include surplus of labor. So from this view, it can be derived that retrenchment means termination on any ground other than the grounds mentioned in the definition. So, the courts in Hariprasad Shivshankar Shukla versus A.D. Divakar and Messrs. Gamnam India Limited versus Sri Niranjan Das and Kamlesh Kumar Rajnikant Mehta versus Presiding Officer Central, in all these cases, the retrenchment it was held that retrenchment means discharge of surplus of labor or staff by the employer, and such surplus may be for any reason. So, for any reason whatsoever, reason means only discharge of surplus of labor or staff. The surplus may be of any reason, not the termination may be of any reason. It is only that surplus may be of any reason. Let us look into the procedure for retrenchment, and it is mentioned in section 25G of ID Act 1947. The well-recognized principle of retrenchment is first come, last go, and the last come, first go. Any employer who wants to terminate the surplus labor has to terminate the services who have joined the establishment recently. The services of seniors are retained and the juniors are terminated. We have a case law in this, Om Oil and Oil Seeds Exchange Limited versus their workmen. In this, the court held that the management can act in good faith and retain the services of the junior who have special qualifications and whose services are required for the very good running of the business. So this is the procedure for retrenchment. And if there is any kind of re-employment for the retrenched workman, it is mentioned under section 25H. When a workman has been retrenched by the employer on the grounds of surplus staff, such workmen should be given an opportunity to join the service whenever an occasion to employ another hand arises. If this provision is not there, the employer may victimize workers to give employment to some other. So this is the re-employment case. And if the retrenched workman has to get compensation, it is defined in section 25F of ID Act 1947. The retrenched workman is entitled for compensation equivalent to 15 days average pay for every completed year of service or any part thereof in excess of 6 months. So average of 16 days per every completed year means for in a year 12 months will be there. So on an average he will get 6 months salary, 6 months wages. And also if there is any kind of surplus work he has rendered, then he will get excess of that surplus work. The employer has to give a notice of 1 month in writing indicating the reasons for retrenchment. If no notice is given, in lieu of such notice, 1 month's salary should be paid. So, a prior notice should be given in writing beforehand in advance of 1 month. And if no notice is given, they have to pay 1 month's salary. So, this is all the procedure, re-employment and retrenchment compensation mentioned in ID Act 1947.